Hi friends, Joe from McClear Law Office, Oshkosh Elder Law and Estate Planning, here with part two of my video on the Secure Act. I did part one just giving a quick overview of three main points about the Act and how it relates to retirement planning and estate planning. Here I'm going to spell it out a little bit more with those three main points. The first one that I brought up was that the bar from contributing to an IRA after the age of 70 and a half has been eliminated entirely. So whereas before you could continue to contribute to your IRA until you reached that old RMD date, which was 70 and a half, then you had to stop. You couldn't put any more into your account. Well, that's gone. Now, if you're working into your 70s or 80s or later, you can keep funneling money into your retirement accounts. That's not going to affect too many folks because just looked it up. Only about 15% of the population works into their 70s. But if that's you and you have no plans to retire just because you hit your 70s, then you can keep building up your retirement account. It has to be active income. So when I said if you're working, that's important. It's not passive income, which would be Social Security doesn't count. Um, uh, Interest doesn't count, dividends don't count. So this would be you're in a business, you're working, you're getting income. That's what you can contribute into your IRA as long as you want to now. The second point, which it seems a little minor, but I think it's a little bit easier now. Whereas before, your required minimum distributions, your RMDs, you had to start taking them the year after you turn 70 and a half. So if you turned 70 last December, a year ago, because it's December right now, last December, then this year, 2019, you would have turned 70 and a half, which means next year, 2020, is when you have to start taking your required minimum distributions from your IRA accounts. They've raised that to the year after you turn 72. Gone from 70 and a half to 72. So you get a little bit extra time when you can hold off on receiving that retirement income to boost your taxes. If you're already taking it, it doesn't apply to you. But if you have been trying to hold off and you want to hold off even further, now you can. So 70. So now it's straight 72. So if you turn 72 in 2019, then it would be if the law was applying here. But here we're talking, it's not going to come into apply next year. But let's just say that the law was, the Secure Act had already been passed. If you had turned 72 in 2019, you wouldn't have to start taking your required distributions until April 1st of 2020. That said, the law is not officially signed yet, so it's not going to be in effect until 2020. So if you're if you turn 70 and a half this year, it's too late. I'm sorry. But if you haven't turned 70 and a half this year, then you have until you're 72 until you have to worry about taking distributions. The last part that I brought up was the stretch IRA. That's the big one, especially for estate planning. To explain how the old rules, still current rules, but soon to be old rules were, you leave your retirement account, your pre-tax retirement account, so not your Roths. You leave your pre-tax retirement accounts to a beneficiary who's not your spouse. Your spouse can roll it over into his or her own retirement accounts and just treat it like they had been building it up themselves the whole time. But you leave it to anybody else, children, grandchildren, brothers, sisters, whomever. The old rules would say, okay, that person has a life expectancy, and Social Security is telling them what it is. And they could use their Social Security life expectancy to decide to create a schedule for when they're going to withdraw from their inherited account. So here's an example here. I had a idea of somebody inheriting who's 60. They get a portion of the retirement account at 60. So Social Security, I looked it up, would give that person a life expectancy of about 23 years. So if there's a $500,000 inherited IRA for that 60-year-old, they could do the minimum and say, well, I only want to take out the minimum, which would be 1/23rd, because they're expected to live 23 more years. 1/23 every year. They could do more, but they couldn't do less. So 1/23 is the minimum. That's about $21,740 a year. So that could be problematic. Could push somebody up into a higher tax bracket. I'm keeping an eye on the Packers-Lions game, and they just tied it up in the fourth quarter. I am a Lions fan, but I hope we lose because it's no good for us. All right, so go Pack, go. So an extra almost $22,000 a year. I mean, there could be some adverse tax consequences. So some folks would say, well, I want to get a bigger stretch out, so I'm going to leave it to my grandchildren instead. So let's just say we're going to skip over the 60-year-old and leave it to that person's child who's only 30 in this scenario. So the 30-year-old receives a inherited IRA of about $500,000. The life expectancy for that person, for a 30-year-old, is just under 82. So we'll say 82. So that's 52-year life expectancy there. So they could divide it up 1/52nd every year if they wanted to it'd be the smartest tax planning, most likely. That's about $9,600 a year as opposed to almost $22,000 a year. So as from a tax perspective, it could be better for them from an income tax standpoint. So that was the old rule. And so some folks would be saying, okay, well, I have a big IRA. I want to make sure my family pays the least amount of taxes. The smart thing to do would be send it to the youngest people. And so grandchildren are sometimes the recipient of a large inherited IRA. Okay, that being said, you learned how the stretch works. Forget it, okay? Because as I said, if you're not leaving it to your spouse, and you leave it to somebody else, odds are that stretch is gone. Now, whether you're 60 or you're 30 or you're 21 or you're 90, it doesn't really matter. The life expectancy is off the table. Now, everyone has to empty out their inherited IRA within 10 years of the date of death. They don't have to have a schedule. They don't have to go 1/10 every year. So if there's $500,000 received, they can take out $50,000 a year. They can take out $100,000 one year, none the next, or they can take out none, and then in year 10 take the whole thing out. That'd be a tax calamity. They wouldn't want to do that. But stretch is gone. You have 10 years. There are some caveats to that. For people who have a terminal disease, they can still use their stretch. For folks who are disabled, they can still use the stretch. For minors, it's a kind of a combination. So it's if you have somebody who's under 18 who's going to be inheriting, they don't have just 10 years to pull all the money out. They get the time it takes for them to get to 18 plus 10 years. So an example, if you leave funds, inherited retirement account to a 25-year-old, they have 10 years until they're 35 to pull out all of the funds. But if you leave it to a 15-year-old, they'll actually have 13 years because it takes 3 years to get to 18 or thereabouts, and then they have another 10. So those are the only caveats there. Hi, it's Joe. I'm sorry, I forgot one. If your beneficiary is less than 10 years younger than you, then they get the full stretch as well. So here we'd be talking most likely siblings or unmarried partners. So if you have someone like that, then they would have the stretch as they would under the old rules. Okay, that's it. Back to the fun stuff. So everything else is that it's going to be 10 years. So this changes a couple of things. One, it might change who you want to leave your retirement accounts to, because if you had chosen your grandchildren with the idea of you getting a better tax advantage, that's probably off the table now. So you might want to rethink it. Maybe you'll say, okay, well, we're going to switch it back to the children because it's 10 years either way. Also, when it comes to estate planning, if you were to be leaving your estate, your IRA in a trust, it used to be that you would want to do so in a pass or see-through trust, a conduit trust, because that way it's more readily identifiable what the life expectancy is going to be used to calculate the distributions. that would mean that for every amount that is pulled from the IRA, it's going to go out of the trust directly to the beneficiary. Now you don't necessarily want that. Accumulation trusts are probably going to be more favorable going forward, meaning that the money that comes out of the IRA does not necessarily have to be distributed to the beneficiary. It could be held in trust. There could be some adverse tax consequences to that, but sometimes those are preferable if the beneficiary, who is maybe still too young, 18, and getting potentially $50,000 or thereabouts, might not want to do that. So you can hold it back. You're going to pay more taxes, but you can hold it back and say until they reach a certain age. Maybe they got other issues going on in their life. I talk about the demons that people face when it comes down to addiction or psychiatric issues. You don't necessarily want to automatically give them funds that you have to pull from a retirement account. Or if the person is going through financial issues like divorce or lawsuits or bankruptcy, if it's distributed, anything that goes out to them, that's fair game for the taking if there's creditors or predators. Held back in a trust, then not necessarily the case. So with a conduit trust, you can't do that. Anything that's pulled from the IRA has to go out to the beneficiary. Accumulation trust, it can stay in the trust. It doesn't have to, but it can. If it does, there's going to be tough tax consequences, but sometimes that's preferable. Whereas before, it was seen with the stretch, getting the stretch was most likely worth it in order to potentially have those issues. But now without the stretch, it might not be worth it. So those are the caveats and the sprinkles I throw onto the first video with regards to the big changes for the Secure Act. It might not affect you much if you're not planning on working into your 70s. It doesn't affect the estate planner much. I mean, in fact, it makes it easier for us to organize everything, knowing that we don't have to jump through hoops to try to get the stretch for however many beneficiaries. Now it's 10 years, so it makes it easier for us from a planning perspective generally. But it could be a big issue for your children or your grandchildren, whoever's going to be inheriting it. It's going to be very likely more problematic from a tax standpoint from their end. It's been in the works for a while. It's finally passing now. Everyone saw this coming, so nothing you can really do about it. It's going to raise more tax revenue, one would have to think, and that's why they're doing it. But now we have to adjust, and so I would highly recommend, as I said in the initial video, go see your financial planner and say, all right, well, maybe we need to switch around who my beneficiaries are because it doesn't matter. We're not going to stretch anymore. And then come see me or another estate planning attorney and say, okay, well, are we leaving this in such a way that makes sense anymore? Because the conduit trust idea may not make any sense. We can switch all of that. Okay, so, oh boy, almost 13 minutes there. I was hoping for only about 5. Okay, still 20 to 22 minutes to go. Pack have the ball. Go Pack, go. I think they can pull this off. I really, really hope so. So that's it. Everybody have a good rest of your year. It's a couple days before New Year's. So, and very happy New Year and a good 2020 to everyone.